violations, recording those violations, and then using their own rules and doctrine as the rope they hang themselves with. Here's how you do it. 1. Master the record. Let the record reflect. Force everything onto the official record. Use these traps. Let the record reflect that the prosecution has failed to produce a verified complaint signed under penalty of perjury. Let the record reflect that no injured party has appeared and no corpus delicti has been established. Let the record reflect that I have not waived any rights knowingly, voluntarily, and intelligently. Why this works? It sets the stage for appeal or dismissal based on due process violations or lack of standing. 102. Demand strict proof of jurisdiction. Trap. File a motion to dismiss for lack of jurisdiction, then follow up with a challenge on the record. Can the prosecution or the court establish subject matter jurisdiction through verified evidence, not presumption? They assume jurisdiction based on silence and your submission. Don't give it to them. SHA-3. Use discovery as a weapon. Request everything. Prosecutor's oath of office. Proof of standing. Victim's sworn affidavit. Policy officer's full training record, body cam footage, and radio dispatch logs. Why it traps them. Failure to comply with delays, Brady violation, due process breach, or grounds to suppress evidence. 4. Weaponize speedy trial rules. Most states have a statutory time limit, e.g. 90
Prince
or 120
Charles
days
Joseph
to
House.
prosecute you. Trap. File a demand for speedy trial. Log every delay, continuance, or failure to proceed. When time runs out, motion to
the
dismiss
living,
with
breathing
prejudice for
man and
violation
woman.
of right to speedy trial. 5. Force the prosecutor into missteps. Start building a motion for judicial notice of prosecutorial misconduct. Anytime they misstate facts, hide evidence, threaten or coerce, overstep in closing arguments. Every violation becomes ammo for appeal, mistrial, or disqualification. 6. Use Latin against them. Sprinkle in doctrines they pretend to understand. Nihil tam naturale est quam eo genere quidque dissolvere, quo collegatum est. Nothing is so natural as to dissolve anything in the manner by which it is bound. Quod ab initio non valet, in tractu temporis non convalescit. What is invalid from the beginning does not become valid with time. This makes them nervous, and judges suddenly tread more carefully. 7. Always say objection, prosecutorial impropriety, motion to preserve the issue for appeal. Every time they do something shady, misquote law, misstate your words, try to backdoor hearsay, hit them with the above line, it freezes them and forces the judge to take note.
Object to everything.
Law, at its core, is a set of rules created by the people to restrain power,
Law is the
protect
law
rights,
of
and
God,
preserve
and
peace. Not the other way around.
we don't go by
But let's
statute
break it down deeper,
codes.
especially from your lens.
We
Law is
don't
a
go
tool,
by
not a
statutes
master.
and codes.
We the people created the Constitution.
We the people.
That means
right.
government is downstream from us.
We
not
are the
above
government.
us. Law is our servant. Real law is derived from
Merit-based
natural rights,
country now.
life,
I'm president of
liberty,
the United
property,
States.
codified through consent,
I'm the
constitutionally
CIV
ratified, not dictated.
MB
Bound by limits, due process, equal
220099.
protection, no cruel or unusual punishment. When law no longer serves justice, it becomes a weapon of oppression, not a protector of peace. Natural law versus legal positivism. Natural law. Rights
Legal
exist by virtue of being human.
means
Law
they
must
have
serve
took
these
God
or
out
it
of the
is void.
equation. They go
Legal
with
positivism.
statutes and
Law
codes,
is whatever the state says it
and
is.
we go with the laws
This is
of
the corrupted
God.
version, used to justify slavery, segregation, and now administrative tyranny. You're already fighting from the natural law position, where truth, fairness, and liberty are not optional. Real law is not arbitrary, a law that creates crime where there's no victim, enforces payment without ability, silences truth-tellers, rewards corruption, is not law. That's policy masquerading as law, enforced at gunpoint for profit. Law is a mirror. It reflects the morality of a people, the corruption of a regime, the health of a nation. When good people stay silent, the mirror breaks, and tyrants rewrite the rules. You want the real definition? Here it is. Law is the codified will of the people to restrain corruption, protect liberty, and serve justice, not authority. Let's break down the shitfuckery in the Cypress doctrine. Raw, real, and unfiltered. 1. Robbing the victims blind. Cypress pretends to serve justice by redirecting leftover class action money. But the real people harmed, they often get pennies or nothing at all. Instead, the court waves its magic wand and gives the cash to similar causes, usually groups that are politically convenient or aligned with the lawyers and judges involved. Example of shitfuckery: a tech company invades privacy. Settlement, $10 million. Victims get 42 cents each. The surplus sent to a privacy non-profit founded by a judge's friend. 2. Legalized laundering. It's a legal laundering machine. Lawyers funnel money through the guise of public benefit, but the real winners are attorneys, huge fees, non-profits, often cronies, corporations who avoid real damage. It's not justice. It's a pay-to-play system where victims are used as leverage, then discarded once the check clears. 3. The judicial circle jerk. Judges handpick third-party recipients. Often these orgs donate to political causes, are staffed by insiders. Advanced narratives aligned with state or institutional interests. So instead of making victims whole, the money becomes fuel for the judicial industrial complex. 4. Smoke and mirrors accountability. Cypress is sold as better than nothing. But that's bullshit logic. Justice isn't about close enough. It's about making people whole, not recycling justice through a charity shell game. They weaponize the idea of public benefit to sanitize what is essentially embezzlement with a robe on. Top 5. Constitutional disrespect. It violates due process. No remedy for actual injury. No consent from class members for where their compensation goes. No accountability for fiduciary misconduct. Cypress flips "we the people" into "we the panderers." Cypress is the judicial equivalent of stealing your lunch money, buying a statue of you with it, and calling that justice. It's all optics, all corruption, all shitfuckery. The Cypress doctrine, from the French "si près comme possible," meaning as near as possible, is a legal principle primarily used in trust and class action law. Its purpose is to salvage a charitable intent or settlement when the original objective becomes impossible, impractical, or illegal to achieve. Nub 1. Origins and function. Charitable trusts. If a donor sets up a trust for a specific charitable purpose, e.g. helping a disease that no longer exists, and that purpose can no longer be carried out, the court may redirect the funds to a similar charitable goal instead of letting the trust fail. Class action settlements. In modern US law, Cypress is also used when distributing settlement funds. If it's not feasible to distribute funds to every class member, a court may allow the money to go to a third party whose work indirectly benefits the class, e.g. a consumer protection group in a consumer lawsuit. None of 2. Requirements. To apply